Today's deep dive is a strictly utilitarian, highly technical analysis of Title I of the Code of Ordinances for Grand Rapids, Michigan. No fluff, no preamble. For you, the listener who wants to understand the absolute, uncompromising mechanics of how a city governs itself, this is your blueprint. We are looking at the exact administrative, legislative, and financial source code that makes a municipal government function.
Right. Our source material is the actual text of the city code itself, specifically chapters 1 through 8. This covers administration, city commission rules, elections, administrative service, pension and retirement benefits, and boards and commissions. We are breaking down the actuarial mass, the legal definitions, and the structural hierarchy.
Okay, let's unpack this codification, starting right at the foundation in Chapter 1, legal mechanics.
It is the perfect place to start because, well, before a city can enforce a law, it has to establish exactly what a law actually is and how it is maintained. The code begins by explicitly ordering its own publication and establishing a highly specific distribution protocol.
Yeah, it's not just handed out to everyone.
Exactly. The text mandates that the code must be available to the public for examination at no cost at the office of the city clerk, or it can be purchased at a price determined by that clerk. But internally, the code assigns strict responsibility for its physical maintenance to a specific list of city officers.
The text dictates that every individual holding the office of mayor, city commissioner, city manager, deputy and assistant city manager, service group director, city clerk, city attorney, city treasurer, assessor, and city comptroller is required to receive a copy. And the code strictly dictates that any officer or employee issued a city code is personally responsible for its upkeep.
It treats the code not as a casual reference book, but as a critical piece of municipal equipment. Furthermore, when an officer leaves their position, the text explicitly states the code remains the property of the city. It must be turned over to their successor or back to the city clerk.
And changing that code is a rigid, almost mathematical process. You don't just cross out a line and write in a new one. The text mandates a precise copy-paste formula for any amendment. It must be done by ordinance, and the title of each amendatory ordinance must follow exact phrasing.
I mean, the phrasing is non-negotiable.
Right. For example, to insert a new section, the text dictates the phrasing must read, quote, an ordinance to amend the code of the city of Grand Rapids by adding a new section, end quote, followed by the specific numerical designations.
What's fascinating here is the utilitarian necessity of that linguistic rigidity. In municipal law, ambiguity is a massive liability. By forcing every single legislative change through that exact linguistic filter, the city ensures there is an unambiguous legal record of what is being altered, added, or repealed. It leaves zero room for procedural misinterpretation.
But within that rigid text, the code draws a really interesting line between what is legally binding and what is just helpful formatting. Section 1.6 distinguishes between the official and unofficial elements. The code states that the only official authoritative elements are the section numbers and the text of the sections themselves. Everything else is unofficial.
That is a crucial legal distinction. The code specifically points out the catch lines. These are the bold-faced titles immediately following the section numbers. The text explicitly warns that these catch lines are not substantive parts of the code.
So basically, you can't go to court and use the bold header of a section to argue your case.
Precisely. The text states they cannot be used to construe the substantive portions more broadly or more narrowly than the actual text indicates. The preface, the table of contents, the index, the editor's notes, they exist purely to assist the user. They hold absolutely no authoritative legal weight. If there is a contradiction between a helpful, bold title and the dense legal text below it, the dense text wins every single time.
That brings us to the actual legal definitions, where the code establishes the precise parameters for how words are applied throughout the entire municipality. And this is where it gets highly analytical. Take the definition of a person. In normal conversation, a person is a human being. But the code states that person shall include any individual, co-partnership, corporation, association, club, joint adventure, estate, trust, and any other group or combination acting as a unit.
By establishing that sweeping, inclusive definition at the very beginning of the code, the municipality closes a massive enforcement loophole. It ensures that no entity can claim exemption from a city ordinance by arguing they do not meet the biological definition of an individual. If a local business operating as a joint adventure or a legal trust violates a zoning ordinance, they are subject to the exact same regulatory and penal mechanisms as a single human being. The code does the same thing with physical geography, breaking down the city's infrastructure with incredible granularity. A public place is broadly defined as any place the public resorts to or travels,
whether owned by the city, the state, or even a place the public resorts to by custom. But when it separates pedestrian and vehicular infrastructure, the definitions get extremely tight. Street, highway, and alley means the entire width subject to an easement for public right-of-way whenever any part is open to the public for travel.
And notice the utilitarian distinction it makes for an alley. It is specifically defined as a secondary means of ingress and egress from a property. It classifies the infrastructure purely by its functional utility.
Conversely, a sidewalk is strictly defined as that portion of a street between the curb lines or lateral lines and the right-of-way lines, which is intended for the use of pedestrians.
If we connect this to the bigger picture of law enforcement, these physical boundaries are critical. If an ordinance dictates a rule regarding snow removal or obstructing a sidewalk, the legal parameter isn't a vague concept of a walkway. It is bound exactly by those curb and right-of-way lines. It mathematically defines where a street ends and a pedestrian path begins.
And that precision directly feeds into the enforcement mechanism. Section 1.13, which establishes the general penalty for violating any provision of the code. The base penalty is strictly defined. Unless another specific penalty is expressly provided elsewhere, every person convicted of a violation shall be punished by a fine of not more than $500 or by imprisonment for not more than 90 days or by both. Plus, they have to pay the costs of their prosecution.
Though it is important to note the text provides a carve-out for municipal civil infractions regarding those prosecution costs. For those civil infractions, the code establishes a separate liability for costs of not less than $10 and not more than $500.
But the real teeth of the enforcement is found in subsection 5 of section 1.13. This is the compounding mechanism. It states that each act of violation, and every day upon which any violation is permitted or suffered to exist, constitutes a separate violation and shall be punished separately.
This is a mathematical hammer designed purely to force immediate compliance. If a code violation, say, an illegal structure persists for 10 days, the city does not view that as a single $500 issue. Legally, it is 10 separate distinct offenses. That carries a maximum potential penalty of $5,000 and 900 days of imprisonment. It ensures that paying a single fine cannot simply be absorbed as the cost of doing business while continuing to violate the code.
But what happens if someone challenges one of these strict ordinances and a judge agrees it's unconstitutional? Does the whole city code fall apart? Section 1.14 prevents that with a severability clause. It explicitly states that if any provision or section of the ordinance is held invalid, that holding shall not affect the validity of the remaining provisions. The legislative intent is clearly stated, is to protect and preserve the peace, health, safety, and welfare of the city.
Severability is a standard, essentially defensive legal mechanism. It insulates the broader, complex machinery of the city government from total systemic collapse. If one specific ordinance regarding, say, a noise violation is successfully struck down in court, the severability clause acts as a legal firewall. It ensures the chapters governing the police department, the water supply, and the tax code remain entirely intact.
Let's look at the administrative mechanics of managing risk in Section 1.12. Whenever the code or any city contract requires someone to file proof of insurance or a bond, the city's risk manager determines if it actually complies with city requirements, and the city attorney has to approve the form of any bond. But the strict part is the cancellation policy. All proof of insurance filed with the city must guarantee that the city will receive 30 days prior written notice of cancellation before the stated expiration date.
And it goes further. If the expiration date of the insurance happens to precede the end of the contract term or the license year, the insurance must provide 30 days prior written notice of an intention not to renew. The city refuses to be caught blind by a lapsed policy.
However, the code does grant the risk manager discretionary authority here. The risk manager can modify or waive these insurance requirements, accept irregularities, or even accept a letter of credit instead of a bond if, in their judgment, the requirement poses an unnecessary hardship and the city remains adequately protected.
This is a highly calculated injection of administrative flexibility into an otherwise unyielding system. It acknowledges that rigidly applying the exact same insurance demands to a massive construction firm and a small temporary vendor might result in administrative gridlock. It delegates the authority to balance risk and utility directly to the risk manager.
Moving from the foundational code to the operational structure, we enter Section 2, the Legislative and Administrative Framework, which covers Chapters 2, 3, 4, and 5. This dictates exactly how the City Commission, the governing body, operates. Section 1.21 mandates that the City Commission must meet in regular session twice each calendar month on Tuesdays. Section 1.22 dictates the timing. At least one regular meeting each month must be held in the evening at 7 p.m., and the remaining regular meetings must be held in the afternoon at 2 p.m.
The physical location is also tightly regulated. Regular meetings are anchored to the City Commission chambers on the 9th floor of City Hall. However, the code permits a specific deviation. The Commission can leave City Hall up to 3 times per year to hold regular meetings at locations within the various wards of the city. To maintain compliance with the state's Open Meetings Act, the Commission must annually adopt a schedule showing the exact dates, times, and places of these meetings by resolution.
Now, when that commission is operating, they hold a severe investigatory tool, the subpoena power, outlined in Article 2 of Chapter 2. This isn't just asking nicely for information. This is legal compulsion. The city clerk, acting on instructions from the mayor, any commissioner, or the city attorney, issues subpoenas in the name of the mayor and under the corporate seal of the city.
And this subpoena can direct any person to appear before the commission or a committee to testify, or to produce books, records, contracts, or papers. The logistics of serving it are purely functional. It can be served by an officer designated by the Director of Public Safety, or simply by any person over the age of 21 years by delivering a copy directly to the individual.
The penalty for ignoring the subpoena is an incredible escalation of legal force. First, if a person fails to appear or refuses to testify, they face conviction in the 61st District Court and are punished under that general penalty we just analyzed, the $500 fine and 90 days.
But the code anticipates that a municipal fine might not be enough leverage in a high-stakes investigation. Section 1.28 provides a secondary, heavier escalation. The official who ordered the subpoena can bypass the district court and petition the circuit court for the County of Kent. The circuit court can then issue its own subpoenas and court orders demanding compliance.
And if someone does show up but lies, Article 3 explicitly states that any person required to take an oath before the mayor, city clerk, or a committee chairman who willfully swears falsely regarding any material fact is guilty of perjury and shall be punished as provided by state law.
Think about the mechanics of what this establishes. The municipal government has built-in code-authorized capacity to legally compel testimony, back that compulsion with daily municipal fines and jail time, elevate the compulsion at the county circuit court level to utilize state judicial authority, and threaten felony state-level perjury charges for dishonesty. It ensures the city commission has completely unimpeded access to the factual data it determines is necessary to govern.
But to actually elect that commission, the city has to be divided into manageable mathematical zones. Chapter 3, Article 1 outlines the ward apportionment. Grand Rapids is divided into exactly 3 wards, and the code defines these wards using hard physical infrastructure.
Which is vital from a utilitarian perspective. If you define a political boundary by neighborhoods or vague landmarks, they can shift. By defining them through physical infrastructure, you lock the electoral map into the actual concrete and geography of the city.
Let's trace these lines exactly as the code dictates. The first ward encompasses all the part of the city lying westerly of a line that begins at the center line of the Grand River at the north city limits. It runs south down the river to the vacated Conrail Railroad center line, goes southeasterly along the railroad to Fulton Street, east to Jefferson Avenue, south to Burton Street, east to Eastern Avenue, and south to the city limits.
The second ward contains the area easterly and northerly of a line commencing at the Grand River at the north city limits near 4 Mile Road. It moves south to that same Conrail Railroad, southeasterly to Fulton Street, east to Jefferson Avenue, south to Wealthy Street, east to Lake Drive, and southeast along Lake Drive to the common boundary with East Grand Rapids.
And the third ward covers the remaining area. It's easterly and southerly of a line starting at Eastern Avenue at the south city limits, moving north to Burton Street, west to Jefferson Avenue, north to Wealthy Street, east to Lake Drive, and southeast to the East Grand Rapids boundary. Within those 3 hard-coded wards, the City Commission has established exactly 74 election precincts.
These aren't just arbitrary lines on a map. These boundaries are the fundamental architecture of municipal representation. By locking them into the code via the Grand River and specific major avenues, the city dictates exactly how its population is divided for the purposes of distributing political power across the 1st, 2nd, and 3rd wards. Changing the balance of power requires officially amending the text of the geographical boundaries.
Once that commission is elected from those wards, they have to run the city's administrative service, which is detailed in Chapter 4. The power dynamic is clearly coldly established in Section 1.71. The City Commission appoints exactly 4 officers: the city manager, the city attorney, the city clerk, and the city treasurer.
And then Section 1.72 draws a hard line. It establishes that the entire administrative service of the city, every other department and employee, with the exception of the attorney, clerk, and treasurer, is under the direct supervision and direction of the city manager. The city manager is the absolute operational hub.
Section 1.141 explicitly mandates that the city manager shall see that all laws, ordinances, and rules adopted by the commission are properly enforced. The manager must attend all commission meetings and appoint an administrative assistant. If the manager is absent, the deputy city manager or the administrative assistant temporarily assumes their full operational authority.
We see this top-down hierarchy perfectly applied to the specific departments, like the police department in Article 2. It is headed by the superintendent of police, who reports to the manager. Section 1.82 strictly and exclusively defines the 6 functional pillars of the police department.
Let's break those 6 functions down. Number 1, operation of motor and foot patrol units for routine investigations and maintenance of law and order. Number 2, maintenance of the central complaint desk, police records, criminal identification, and custody of property. Number 3, investigation of crimes, elimination of illegal liquor traffic and vice, and preparation of evidence for prosecution. Number 4, prevention and control of juvenile delinquency and removal of crime hazards. Number 5, enforcement of traffic laws, school patrols, and coordination of traffic violation prosecutions. And number 6, the operation of community policing units in the city's neighborhoods.
What's fascinating here is how the code inextricably links operational function directly to municipal finance. If we look at Section 1.86, it contains a highly specific conditional funding trigger for those community policing units mentioned in function number 6.
Here's where it gets really interesting. The text states that community police officers shall continue to be funded only while a very specific tax structure is in place. Both a city income tax of 1.5% must be in effect for corporations and resident individuals, and a city income tax of 0.75% must be in effect for non-resident individuals.
That exact same fiscal contingency is applied to the fire department. The fire department, headed by the fire chief, is charged with fire extinguishment, hazard abatement, and educational programs. But Section 1.95 explicitly states that a fire squad located at the LaGrave Avenue station, which provides fire response to any area of the city, is funded only as long as that exact same 1.5% resident and 0.75% non-resident city income tax reigns in effect.
That is a staggering utilitarian legal mechanism. The code basically hardwires a financial hostage situation for specific physical city services. By writing this directly into the ordinance, the city legally tethers the existence of neighborhood community police officers and a LaGrave Avenue fire squad to the sustained approval of that exact income tax rate.
If that specific tax rate falls, the legal mandate to fund those specific operational units immediately evaporates. The code doesn't say we will try to fund them. It says they are funded only while the tax exists. It is a stark mathematical example of how municipal finance literally dictates the physical deployment of emergency services.
Looking at broader administrative policy in Chapter 5, we see another highly efficient mechanism. It's how the city delegates enforcement authority through appearance tickets. You'd assume only police officers issue tickets, but Section 1.152 outlines a massive, decentralized enforcement web.
While the police chief can issue tickets for any code violation, relying solely on sworn officers for administrative violations is an inefficient use of resources. So the code explicitly delegates ticketing authority to specialized directors based on their domain.
Exactly. The Director of Housing and Community Development can legally issue appearance tickets for violations regarding zoning, historic preservation, building regulations, plumbing, electrical, and mechanical codes, as well as property nuisances like dangerous structures or even abandoned refrigerators.
The delegation continues across the entire administrative service. The city clerk handles tickets for administrative licenses, taxicabs, pawnbrokers, and coin-operated laundries. The Environmental Protection Director is authorized to issue tickets for solid waste, sewage disposal, air pollution, and noise control. The fire chief issues tickets for fire prevention violations, and the park director has authority over parks, trees, public cemeteries, and city markets.
This allows specialized departments to directly police their own regulatory domains. A building inspector doesn't need to call a police officer to write a ticket for an illegal plumbing setup. The code grants them the direct administrative power to initiate the penal process themselves.
Chapter 5 also contains the city's fair employment practices in Section 1.150. It dictates that no city department, official, or agent shall refuse to hire or otherwise discriminate regarding terms of employment because of race, color, religion, national origin, or ancestry, unless it is based on a bona fide occupational qualification. Furthermore, it explicitly protects individuals based on sex and contains a highly specific parameter regarding age.
The code specifically protects individuals between the ages of 18 and 60 from age discrimination.
That strict numerical boundary between 18 and 60 is a highly calculated parameter for the application of municipal age discrimination protections within city employment. The text also includes a remarkably utilitarian carve-out. It notes that it is not an unfair employment practice to refuse to select an individual over the age of 35 for an apprenticeship or on-the-job training program intended to last more than 4 months.
Let's unpack the logic of that. It's a cold economic calculation embedded in the Civil Rights Code. By capping the protection for apprenticeships at age 35, the city is prioritizing the economic viability of long-term training investments. They are legally protecting their right to ensure that if they invest extensive time and money training someone, they get decades of functional municipal service out of that individual before retirement.
Which perfectly transitions us to Section 3 of our analysis. The complexities of pension and retirement benefits contained entirely within Chapter 7. This is undeniably the most mathematically dense, actuarially complex portion of the city code, because making sure employees have a pension isn't just about saving money. It requires navigating a labyrinth of federal law and market volatility.
Right out of the gate, Section 1.191 explicitly states that the General Retirement System was amended specifically to comply with the Federal Pension Protection Act of 2006. The definitions section is loaded with IRS code references just to maintain federal tax compliance. It cites 415 limits in sections 125, 132.4, and 457B just to define what legally counts as compensation.
The city code establishes 2 completely distinct retirement systems. The general retirement system covers the regular administrative employees, while the police and fire retirement system covers the sworn personnel. The actuarial assumptions and the core benefit structures differ significantly because the physical demands of the jobs differ.
For example, the minimum service retirement age or normal retirement age is 62 for members of the general retirement system, but it is 55 for members of the police and fire retirement system.
Let's examine how the city mathematically calculates the financial health of these massive systems. They use a metric called valuation assets. Valuation assets are the recognized value of the current plan assets used to determine exactly how much the employer the city needs to contribute that year to keep the fund solvent. But they don't just look at the raw stock market value on a given day because that would cause budgetary chaos. They use a market smoothing mechanism.
Let's break down this smoothing mechanism because the code details a major historical shift. Prior to the fiscal year beginning July 1, 2009, the general system recognized capital value changes by taking 33.3% of the change immediately, 33.3% in the next fiscal year, and the final 33.3% in the second subsequent fiscal year.
Think of the smoothing mechanism like a municipal shock absorber. If the market crashes, the city doesn't take the full financial hit to its required contribution all at once. Prior to 2009, they spread the impact over 3 years. However, post-2009, the code dictates that the smoothing method was fundamentally altered for both the general and the police and fire systems.
The new rule mandates a market-related asset value method that recognizes 20% of the investment return immediately and 20% in each of the next 4 subsequent fiscal years. Why the shift from 3 years to 5 years?
It flattens the mathematical curve of the city's liability even further. By spreading the recognition of investment gains and losses over a 5-year period instead of 3, the city severely insulates its required annual budget contribution from extreme year-over-year market volatility. It prevents a scenario where a single bad year in the stock market forces the city to suddenly double its pension contributions, which would require slashing physical city services to balance the budget.
Now, what does the actual retiring employee get? The benefit relies entirely on the calculation of their final average salary, or FAS. For the general system, the FAS is generally calculated as the average of the highest annual compensation rates during 3 consecutive calendar years of employment.
But compensation is not just your base salary. The code introduces highly complex variables called additional compensation items, or ACI, and the exact mathematical formula for incorporating ACI shifts depending on your specific job classification and bargaining unit.
It's incredibly fragmented. For example, members of the crime scene technicians group have an actuarially determined addition to their FAS. The code calculates it by dividing the average of the ACI for that entire group over the previous 3 years by the annualized average of the group's covered payroll for the previous 5 years.
And if you look at emergency communications operators, the 911 dispatchers, they use a 5-year average of ACI divided by the 5-year average of covered payroll. Over in the police and fire system, the FAS calculation contains unique, bargained variables. For instance, a firefighter retiring after January 1st, 2012, is allowed to include the monetary equivalent of up to 6 days of accrued vacation time directly into the calculation of their final average salary.
By injecting these highly specific union bargain variables into the foundational FAS math, the city code is accommodating nuanced labor agreements within the otherwise rigid actuarial architecture of the pension formula.
It also means the administrative burden on the city is massive. They aren't running one simple math equation for everyone. They're running dozens of specialized formulas based on hire date, classification, and union contract. And we see this exact same fragmentation in what the employees are required to contribute from their own paychecks.
The required contribution rates listed in the Members' Deposit Fund for the general system are a staggering array of percentages. For non-represented members hired after September 5, 2010, the code dictates they may contribute 10.20%, 8.95%, or 7.28%, depending entirely on the individual multiplier election they choose.
It operates like a financial menu. Emergency communications operators hired after April 1st, 2012, must select from an even larger menu of contribution rates: 10.63%, 9.38%, 7.71%, 6.58%, or 5.36%.
This complex matrix of percentages reflects a modern transition away from monolithic, one-size-fits-all pension plans toward highly individualized actuarial trade-offs. The code explicitly allows an employee to pay a higher specific percentage of their current salary to purchase a mathematically higher multiplier for their future retirement allowance.
But again, think of the utilitarian mechanics required to execute this, the payroll and actuarial software required to track, calculate, and correctly deduct these wildly varied percentages across thousands of employees, ensuring absolute compliance with the code is immensely sophisticated.
And the complexity continues after the employee retires, specifically regarding mechanisms for supplementing the baseline pension. Historically, the code provided this through what is called the 13th check, detailed in Article 4 for police and fire and Article 6 for the general system. To even be eligible, a retirant must have been receiving a system allowance for 5 full years.
And the issuance of this 13th check is not guaranteed. It is entirely dependent on a highly specific fund availability mathematical trigger based on the stock market.
Let's walk through the math of that trigger. The city averages the net annual market value investment rate of return for the preceding 5 years. If that 5-year average return is less than 8%, the trigger fails. No funds are distributed. 0.
But if that 5-year average exceeds 8%, the trigger is pulled. The code dictates that 50% of the amount in excess of 8% is multiplied by the funds available in the benefit reserve fund. That resulting sum becomes the net distributable reserve.
Once they have that pool of money, they don't just divide it equally. The distribution is based on a rigid point system. A qualified retirant receives 1 point for each full year of retirement, up to a maximum of 15 points. Then, they add 1 point for each year of service the employee had at retirement.
The city takes the retirees' total points and calculates them as a percentage of the total points of all eligible retirees. The distributable reserve is then allocated to the individual based precisely on that calculated percentage. Furthermore, for police and fire, the benefit for certain ranks is mathematically increased by an artificial 20% after that initial calculation.
But when you read the modern amendments to the code, it reveals a definitive legislative pivot entirely away from the 13th check. The text dictates that for employees terminating after specific dates, the 13th check mechanism is eliminated. Instead, they are shifted to an escalator increase.
For example, firefighters terminating after July 1st, 2007, and police officers terminating after December 17, 2008 are permanently excluded from the 13th check. In its place, the code dictates that firefighters receive a flat 1.5% non-compounding increase to their pension after 2 years of retirement. Police officers receive a 1.0% non-compounding increase after 5 years.
The general system features the exact same phase-outs. Non-represented members terminating after July 1st, 2014 receive a 1.0% non-compounding escalator after a 7-year waiting period.
If we connect this to the bigger picture of municipal finance, this is a monumental stabilization effort. The city is systematically excising a volatile, market-dependent bonus system that required complex annual calculations of excess returns. They are replacing it with a fixed, mathematically predictable, non-compounding annual liability. It is infinitely easier to actuarially project a flat 1% increase than it is to guess what the stock market will do in 5 years.
Alongside the pension payments, the Code establishes highly structured Medicare supplemental trust funds in Article 7 to assist retirees with health insurance premiums. Because, as we know, a pension is useless if it's entirely consumed by medical costs. Separate trust funds are created for the different groups, including Firefighters Local 366, the Police Officers Labor Council, the Association of Public Administrators, and Emergency Communications Operators.
The funding mechanism dictated by the code for these trusts is identical across all the groups. The city contributes an amount equal to exactly 0.5% of the annual salary rate of the covered employees. This is paid in separate quarterly payments strictly in January, April, July, and October.
Each of these trusts is administered by a joint committee. The composition is highly regulated. It's typically 7 members, 4 appointed by the respective union and 3 appointed by the city manager.
That joint committee holds the responsibility for investing the trust funds and mathematically determining the annual benefit amount. This is the money distributed to insurance companies to cover the Medicare Part A and B supplement premiums or an approved alternate insurance. However, the code places a severe utilitarian cap on this power.
Section 1.258 strictly limits the maximum amount available for distribution in any given fiscal year to 50% of the value of the trust fund.
This mathematical cap is the ultimate failsafe. It legally prevents the Joint Committee from rapidly depleting the trust assets in a single year to cover spiking insurance premiums. By capping the outflow at 50% of the total value, the code artificially ensures the long-term baseline mathematical viability of the trust fund.
But the final and perhaps most significant evolution in the city's retirement mechanics is found in Article 8, the City of Grand Rapids Defined Contribution, or CGRDC, plan. Everything we've discussed so far, the smoothing, the FAS, the multipliers, that's all a defined benefit system. Effective January 9, 2012, the city began shifting new hires away from that defined benefit system entirely.
The code mandates that employees hired after highly specific dates, such as May 25, 2011 for GREU members and July 1, 2014 for APGR members, are placed strictly into the defined contribution plan. The financial terms laid out in the code are absolute: a 6% employer contribution, a 6% employee contribution, and a 5-year vesting period.
That is a staggering simplification of the municipal code.
It is a total transfer of long-term investment risk. In the old system, the city held the risk. If the market crashed, the city had to make up the difference using complex smoothing formulas to guarantee the employee's calculated FAS benefit. By freezing the intake of the defined benefit systems and migrating strictly to a defined contribution model, the city stabilizes its future actuarial liabilities entirely. They replace decades of complex calculation and unfunded liability risk with a flat, predictable 6% payroll expense. The risk of the market underperforming is transferred entirely to the individual employee's 401k style account.
This brings us to the final section of our analysis, Section 4, covering the boards, commissions, and civil rights established within Chapter 8. The code doesn't just let the city commission run everything, it delegates specific powers to citizen boards. The general provisions in Article 1 apply to all of these boards. Section 1.331 mandates that any vacancy is filled strictly for the remainder of the unexpired term, maintaining the staggered expiration dates.
And the code is clear on accountability. The appointing authority can remove any board member for cause, but the member is legally entitled to demand a public hearing within 10 days of receiving the removal notice.
However, the code strictly limits the scope of this hearing. It is not a legal appeal where a judge decides that the removal was fair. The text explicitly states it is solely an opportunity for the appointing authority to publicly state the reason for removal and for the removed member to publicly respond. Once that public airing is complete, the removal stands.
The code also explicitly defines what constitutes cause for removal. It includes failing to file a sworn oath of office or failing to comply with strict attendance standards. Furthermore, Section 1.334 establishes a baseline utilitarian rule across all these bodies. All members of boards and commissions shall serve without compensation.
One of the most legally powerful bodies established in this chapter is the Community Relations Commission in Article 3. Section 1.341 issues a definitive statement of public policy. It declares it contrary to the public policy of the city to deny any person their civil rights or discriminate against them because of race, color, creed, religion, national origin, ancestry, age, gender, marital status, disability, height, weight, sexual orientation, or gender identity.
The text then shifts from a broad declaration to explicit functional definitions of how these civil rights apply within the city limits. In the realm of employment, the code makes it strictly unlawful to refuse to hire, to discharge, or to discriminate based on those traits unless it is a bona fide occupational qualification.
In housing, the code protects the opportunity to purchase, lease, or obtain financial assistance. And here, it explicitly adds 3 specific protections to the list: familial status, source of lawful income, and public assistance recipient status.
But again, we must look at the utilitarian legal mechanics of the code. Just as it established protections, it establishes specific exceptions. Section 1.344 explicitly states it is not a violation for the owner of an owner-occupied one-family or two-family dwelling to restrict occupancy of those specific types of dwellings.
Moving to public accommodations, the code guarantees equal access to the goods, services, and facilities in hotels, restaurants, barbershops, theaters, and public transportation without discrimination. But a law is only a suggestion without an enforcement mechanism. The Community Relations Commission is tasked with actively investigating these complaints.
And here is where the mechanical structure of the entire Code of Ordinances ties itself perfectly together. If individuals or businesses refuse to provide necessary factual information during a civil rights investigation, the Commission doesn't just give up. Section 1.345 allows the Community Relations Commission to officially report the failure to cooperate directly to the City Commission.
Which links us directly back to Chapter 2. The City Commission can then invoke the exact subpoena powers we analyzed earlier.
Precisely. The municipal government has the built-in code-authorized capability to use the city clerk to issue a subpoena, demand the production of employment or housing records, and back that demand with the threat of 61st District Court fines, circuit court intervention, and state-level perjury charges. The code provides the investigative body with the ultimate legal teeth necessary to compel cooperation.
The city also operates specialized commissions for targeted utility, like the Grand Rapids Housing Commission under Article 5. It consists of 5 members appointed by the city manager for 5-year terms. And in compliance with state law, the code explicitly mandates that at least one member of this commission must be an actual tenant of public or subsidized housing.
Administratively, this commission has the sole authority to fix the compensation and terms of employment for its own staff. But they are bound by extremely strict financial reporting metrics to the broader city government. The code mandates they must submit a detailed statement of financial position and cash flows to the city comptroller every single month and provide an annual accounting backed by an independent audit within 90 days of the fiscal year's close.
We also see the Grand Rapids Historical Commission in Article 6, consisting of 13 members appointed by the mayor for 3-year terms, tasked with compiling and protecting the city's historical source material. But without question, the most administratively impactful board in this chapter is the Local Officers Compensation Commission found in Article 7.
This commission consists of 7 registered electors appointed by the mayor for 7-year staggered terms. Their sole, highly specific function is to determine the salaries of the mayor, the city commissioners, and the controller.
If we connect this to the bigger picture of municipal integrity, the Compensation Commission acts as an isolated, independent fiscal mechanism. It is mathematically designed to prevent elected officials from directly setting their own immediate pay rates.
They meet in odd-numbered years for no more than 15 session days. Once they determine the appropriate salaries, that legal determination is filed directly with the city clerk. And the code establishes a fascinating procedural trigger. That salary determination automatically becomes effective in 30 days unless it is actively rejected by a 2/3 vote of the city commission.
The mechanics of that rule are brilliant. By requiring a 2/3 supermajority to reject the independent salary determination, the code creates an incredibly high mathematical threshold for the elected officials to override the citizen board. It legally isolates the political body from the financial mechanism of their own compensation.
Which perfectly encapsulates the entire nature of Title I of the Code of Ordinances.
You, the listener, now have a comprehensive, under-the-hood understanding of the structural mechanics of the Grand Rapids municipal government. This utilitarian breakdown proves that a city is not merely a collection of physical infrastructure, buildings, and roads. It is a highly calibrated machine built entirely of unyielding legal definitions, escalating enforcement parameters, actuarial smoothing formulas, and precise administrative boundaries. From the curb lines that legally define a sidewalk, to the 5-year average market returns that trigger a pension supplement, to the exact subpoena powers required to enforce a civil rights investigation. Knowing this text means knowing exactly how the levers of local power and finance are pulled to maintain the reality of the municipality.
As we conclude this analysis, consider this final thought. The text of this code, when read deeply, reveals a steady chronological shift in municipal philosophy. We observe the transition from the volatile, market-dependent 13th check pension supplement to fixed, non-compounding escalators, culminating in the eventual adoption of a flat, predictable 6% defined contribution plan for all new hires. The code is actively migrating away from complex risk toward absolute stability. As you look at your own local government infrastructure, consider the invisible compounding math of municipal pensions and the rigid constraints of administrative codes quietly but absolutely dictate the future financial viability, the physical growth, and the daily operational capacity of the city around you. Welcome to the Deep Dive. Today, we are looking at Chapter 130 of the Code of Ordinances for Benton, Louisiana. Our sources are the exact legal zoning texts pulled directly from the Municode library. Our mission today is to look past the surface of a typical town and examine the microscopic urban DNA. The CUD dictates exactly how people can live, how they can build, and how they can operate businesses. We are going to get as deep into the zoning minutiae as possible.
Yes, we are going to treat this highly technical specification not as a dry legal text, but as a rigid, invisible physics engine that governs reality in Benton. It is a profound reflection of a community's values and its fears, specifically regarding spatial segregation and nuisance mitigation.
I want you to imagine looking at a town through the ultra-focused lens of a city planner. When you look at your own neighborhood, you are actually seeing a manifestation of an intensely specific, legally binding document. The height of a fence, the type of truck parked in a driveway, the setback of a building. It is all determined by this text.
Every single definition and regulation in Chapter 130 exists because a specific situation arose, a situation that needed to be legally controlled or defined. It is not about arbitrary lines. It is about enforcing predictability.
Okay, let's unpack this. Before we can look at the map of the town, we have to establish the vocabulary. Article 1 of this code is dedicated entirely to highly specific definitions. These are the legal gatekeepers of the municipality. Let us start with the legal definition of a family.
In Benton's zoning code, a family is not defined strictly by blood relations or marriage. Modern codes have shifted away from that. Instead, Chapter 130 defines a family as one or more persons living together as a single housekeeping unit. However, there is a strict mathematical cap. It can include not more than 4 lodgers or boarders.
Let us trace the logic of a hypothetical scenario. You buy a 5-bedroom house, you live alone. To offset the mortgage, you rent the other 4 rooms to college students.
Legally, you are compliant. You and those 4 renters share the kitchen and living spaces. You operate as a single housekeeping unit. The code recognizes you as a family. You are permitted to exist in a standard single-family residential district.
But if one of those students has a partner move in, that is a 5th border. You cross an invisible threshold.
The moment you take in the 5th border, your legal reality shifts. You are no longer a family. Under the definitions in Chapter 130, your home is legally classified as a rooming house or a boarding house.
Does the town truly care about the difference between 4 roommates and 5?
It is a vital tool for controlling density. If you are classified as a boarding house, you are operating a commercial enterprise. The physical location where you are allowed to exist on the zoning map changes. You cannot put a boarding house in a standard single-family neighborhood. 5 or more unrelated adults bring a different footprint. More cars, different schedules, altered traffic patterns. Capping the definition at 4 borders protects the character of residential streets without micromanaging leases.
The granularity gets more intense when separating types of communal living. There is an exact distinction between a hotel and a boarding house.
The text defines a hotel as a building providing lodging, with or without meals, for transient guests. The crucial differentiator is the clause stating that no provision is made for cooking in any guest room.
So the lack of cooking provisions defines the hotel room.
In part, contrast that with the definition of a boarding house. A boarding house provides meals and lodging. The critical legal linchpin is the phrase, by prearrangement, and it must be for 5 or more persons who are not transients.
The phrase by prearrangement carries significant legal weight.
It separates a roadside motel from a long-term living situation. A hotel brings unpredictable transient traffic. A boarding house brings a steady, known group of people. The town regulates them differently because their impact on street noise and parking requirements is different.
Let us move from buildings to vehicles. The code's taxonomy of mobile structures is precise. If you own an RV, camper, or trailer, the town has a specific category that dictates where you can park. The code differentiates between a camper vehicle, a travel trailer, and a motorhome.
Let us break down the physical mechanics. A camper is merely the shelter itself. It has no wheels of its own. It is designed to be mounted on a motor vehicle.
Just a fiberglass shell?
Yes. But when you take that shell and mount it onto a pickup truck, it legally transforms into a camper vehicle. The code defines a camper vehicle as the motor vehicle to which the camper is temporarily attached.
The word temporarily is the dividing line. What happens if it is attached permanently?
If a vehicle is originally designed or permanently altered and equipped for human habitation, it becomes a motorhome in the eyes of the law.
And then there is the travel trailer.
The travel trailer is defined as a vehicular, portable structure built on a chassis. It is designed for temporary dwelling for travel, recreational, and vacation uses. It is designed to be hauled along a highway.
A motorhome is driven. A travel trailer is hauled. A camper is the shell. A camper vehicle is the shell temporarily on a truck. This distinction between permanent and temporary leads into the distinction between modular homes and manufactured homes.
This is a critical area of urban planning. First, the manufactured home. Chapter 130 defines it as a structure with sleeping accommodations, plumbing, and electrical connections. Crucially, it is designed and constructed on a chassis.
The chassis is the defining feature.
The code states a manufactured home is capable of being transported on its own wheels or detachable wheels. It arrives at the site complete or in sections. It is not placed on a foundation as required for a permanent structure.
It has a steel frame and wheels. It is inherently transient. A modular home is treated entirely differently.
The definition of a modular home mandates the use of structural insulation panels, or SIPs.
SIPs consist of an insulating foam core sandwiched between two structural facings, usually oriented strand board.
The code is specific. Modular homes are not built on frames. They are built using engineered lumber. They are delivered by a specifically designed trailer. They are set in place by a crane or rail system onto a permanent foundation. Acceptable foundations are pier and beams, a chain wall, or a concrete slab.
A chain wall is a continuous perimeter foundation wall, usually concrete block, supporting the exterior walls. It anchors the building.
That anchoring is the point. The code includes a legal clause stating that since there is no tongue, axles, or frame to remove, the home is considered a permanent structure. It also states the purchase and financing must be evidenced by a valid and enforceable first lien mortgage recorded in the land records. It must be a single real estate transaction.
The town is declaring that legally, this factory-built structure is indistinguishable from a traditional site-built house.
It establishes real property. A modular home adds to the permanent tax base. A manufactured home, because of the chassis and wheels, is treated legally more like a vehicle. Benton treats manufactured homes with extreme strictness.
Before we move on to the map, we must discuss home occupations. If you run a business from a laptop or make items in your house, the town has a rule for this side hustle.
It is classified as a home occupation. The primary philosophy is that a residential neighborhood is zoned for quiet enjoyment. The home occupation must be entirely incidental and secondary to the use of the dwelling for dwelling purposes.
How does the town legally quantify incidental?
Mathematically, the business cannot utilize more than 25% of the floor area of the dwelling.
The average American home is roughly 2,000 square feet. 25% of that is 500 square feet. If your home business expands beyond that footprint, you are legally in violation.
The occupation must be conducted entirely within the dwelling. You cannot have any outside operations. You cannot have outside employees. Only members of the family residing in that dwelling can work there.
If you make custom goods in your garage, you cannot hire a teenager from down the street to pack boxes. They do not reside in the dwelling.
And the code says no article can be sold or offered for sale except those produced by the members of the family residing in the dwelling.
If you buy bulk phone cases from a wholesaler, store them in the 500 square foot spare bedroom, and resell them exactly as they are through an online marketplace, you are not producing the articles.
You are operating a retail and warehousing business. Under this code, that is illegal in a residential zone.
It restricts the individual to protect the neighbors. Delivery trucks dropping off pallets, increased traffic, the 25% limit, the employee ban, the production requirement. These are dampers put in place to ensure a home remains a home.
We have established the building blocks. That brings us to the zoning map itself, the microgeographies of permitted uses. The town is sliced into rigid districts. RA, residence agriculture, up to I2, heavy industry.
Let us start out on the edges of town, the RA district.
It is intended for vacant lands, forestry, and agricultural uses with interspersed dwellings. It prevents scattered, premature business developments that would disrupt future urban planning.
To build a traditional one-family dwelling, you need a minimum of 6,000 square feet of land. For any other permitted use, you need 10,000 square feet. What are those uses?
You can engage in the extraction of oil and gas. You can have a farm. You can operate a racehorse training facility.
Provided it is not a commercial racetrack for pari-mutuel betting.
Pari-mutuel betting is where bets are placed in a pool, and payoffs are calculated by sharing the pool. The town allows breeding and training. But betting windows cross the line into commercial entertainment. Not allowed in RA.
You can apply to the Board of Hotels for a temporary revival church.
The zoning administrator can issue a permit for a temporary revival church for a period not exceeding 1 week.
It can be renewed, but for not more than 3 such periods, an absolute maximum of 4 weeks.
It accommodates community practices while capping the duration, so a temporary tent does not become a permanent unzoned structure.
We move to the business districts, B1, B2, and B3. B1 is a transition zone.
It acts as a buffer between residential areas and heavier business areas. Uses are of a semi-commercial nature: professional offices, art galleries, antique stores. Low foot traffic.
The hours of operation are policed. In a B1 district, no store or shop can be open for business before 7:00 a.m. or after 7:00 p.m.
Compare that to the B2 neighborhood business district. It furnishes retail goods to satisfy daily household needs. Grocery stores, drugstores.
A B2 business has a wider operational window. They can stay open from 7:00 a.m. until 12:00 midnight.
Yes, the geography of the map dictates the hours of operation.
We arrive at the B3 district, community and central business district, located at the convergence of principal thoroughfares.
What's fascinating here is the highly specific nature of the permitted uses in the B3 district. There are nearly 200 specific businesses called out. Banks, hardware stores.
You can manufacture artificial limbs, you can operate a wig shop, a taxidermy shop, manufacture brooms and brushes, coffee roasting.
Let us look closely at use number 75, the food locker plant.
The code permits a food locker plant, renting individual lockers for home customer storage of food. But it includes a parenthetical caveat: cutting and packaging of meats and game permitted, but not including any slaughtering or eviscerating thereof.
You can bring game meat to the center of town. You can rent a locker. The butchers can cut the meat, but the actual slaughtering and eviscerating is forbidden.
The act of evisceration produces biological waste, blood, odor, and health hazards.
It crosses the threshold into an industrial high-nuisance process. You must go to the industrial districts.
Right.
I1 and I2. I1 is light industry.
Manufacturing that does not directly adversely affect nearby residential and business uses. Burial vaults, tents, boats, ice cream, indoor pistol ranges.
I2 is heavy industry. High-impact manufacturing. You can manufacture acetylene gas, ammonia, bleaching powder, chlorine, electric power generating plants, dyestuffs, rock crushers.
Even within I2, certain activities require a special exception approval. Acid manufacture, hydrochloric, nitric sulfuric, animal reduction, manufacture of explosives, fireworks, gunpowder, and meat slaughtering.
The spatial segregation is profound. Quiet stores in B1 close at 7 p.m., foot traffic in B3, light manufacturing in I1, toxic chemicals, explosive powders, and slaughterhouses are pushed to I2.
Article 2 outlines the rules that override the general zoning map, the supplementary regulations.
The lakeside protections for Cypress Lake and Black Bayou Lake. The code states no building permit will be considered without the Lake Commission's review for the area up to 800 feet from the 179.6-foot contour line on Cypress Bayou Reservoir and 800 feet from the 185.0-foot contour line for Black Bayou.
A contour line connects points of equal elevation. The exact elevation line is 179.6 feet above sea level. They drew an invisible 800-foot buffer zone extending outward from it. If your property is 799 feet from that mark, you are subject to review.
If your neighbor is 801 feet away, they're clear. Next is the visibility triangle at intersections. Section 130.41.
You start at the corner of the property where the two street lines intersect. The street line is the legal boundary where the private lot ends.
From that corner point, you measure 30 feet down one street line. Then you measure 30 feet down the intersecting street line. You connect those 2 points with a straight line. This draws a triangle at the corner of the property.
Inside that mathematical triangle, no fence, wall, hedge, or planting can be erected or maintained to a height of more than 3 feet above the curb level.
If a privacy fence or a rose bush falls inside that 30-foot triangle, it is prohibited. If the bush grows to 3 feet and 1 inch, it violates the code. It must be cut down.
The supplementary regulations govern vertical geometry. Every district has a strict height limit. Business districts generally limit buildings to 35 feet or 2.5 stories.
The height limits do not apply to church spires, belfries, cupolas, penthouses, water tanks, chimneys, or ventilators, provided they cannot be used for human habitation.
A factory in I-1 can build a 35-foot tall building, but erect a 50-foot water tank for its sprinkler system. Then we have the protection standards.
Section 130.43. There shall be no production of noise, which, at any boundary of the building site, is in excess of the average intensity of street and traffic noise at that boundary.
The acceptable level of noise changes depending on the lot. A factory on a quiet country road has a low baseline average intensity. It must be extremely quiet at the property line.
That exact same factory next to an 8-lane interstate highway can make a tremendous amount of noise because the baseline average intensity is already 80 or 90 decibels.
There can be no emission of objectionable heat, glare, or vibration perceptible beyond the boundary. No dust, dirt, odors, or smoke in dangerous amounts. No waste stored where it might be transferred off the site by natural forces.
If high winds blow lightweight packing materials from your business across the property line, you are violating the protection standards for improper storage.
Here's where it gets really interesting. Article 3. Residential Plan Unit Developments, or RPUDs. How developers legally bypass these individual lot rules.
Under traditional zoning, a 50-acre tract zoned R1 requires every lot to be exactly 10,000 square feet, with a 30-foot front yard setback, 25-foot rear yard setback, and 10-foot side yards. The developer subdivides the land into identical rectangular boxes.
A rigid cookie-cutter grid. If there is a 10-acre stand of old-growth oak trees, the developer must bulldoze them to conform to the grid.
The RPUD explicitly waives the strict individual district requirements to allow large tracts to be developed as an integral unit. The minimum tract of land must be 3 acres. The overall density cap is 9 dwelling units per gross acre.
The town waives the minimum lot area. The developer can build houses on 4,000 square foot lots, but the overall density cannot exceed 9 homes per acre. All buildings must be set back a minimum of 25 feet from the exterior boundary lines of the development.
Inside the perimeter, you need 10 feet of space between the sides of buildings, and no garage or carport with straight-in access can be closer than 20 feet from an interior roadway.
A standard full-size pickup truck is roughly 19 feet long. By mandating a 20-foot setback for straightened garages, the code guarantees that a vehicle fits entirely on private concrete without blocking the street.
The Planning Commission can grant waivers. If a developer proposes increased density, the Commission can waive standards, provided the site plan provides a minimum of 20% open area, exclusive of parking and streets.
The developer surrenders 1/5 of the land to common open space. In return, they get higher density and lower infrastructure costs.
Let us examine Article 4, Off-Street Parking and Loading Specifications. No land shall be used unless off-street parking facilities are provided.
Each off-street parking space must be an area of not less than 200 square feet net, exclusive of access or maneuvering area.
It must be surfaced with concrete or asphalt, provided with wheel guards or bumper guards, so no part of the vehicle extends beyond the parking space.
Section 130.112. In residence districts, except RA zones, off-street parking facilities shall be used only by vehicles up to 3/4 ton manufacturer's capacity rating and having wheels not to exceed 17 inches.
Having wheels not to exceed 17 inches. By limiting the payload capacity to 3/4 tons and the wheel size to exactly 17 inches, the town effectively bans heavy commercial work trucks from residential driveways overnight.
A dual rear-wheel truck, or dually, has 4 tires on the rear axle and is very wide.
The town does not want a 1-ton commercial truck with 22-inch wheels parked in a suburban driveway. It blocks sightlines. Enforcement is complaint-driven. The 17-inch mathematical threshold removes subjectivity for the zoning officer. They read the tire sidewall and issue the citation.
The parking formulas. A 1-family dwelling requires 1 space. 2-family requires 2. A hospital requires one space for every 2 beds. A restaurant requires one space per 100 square feet of gross floor area.
A 2,000 square foot restaurant requires 20 parking spaces. 20 times 200 square feet is 4,000 square feet of parking space.
Plus the drive aisles and turnaround areas, which usually double the square footage. You are required to pave roughly 8,000 square feet of land for a 2,000 square foot building.
An elementary school requires one space per classroom. A secondary school requires 6 spaces per classroom.
The zoning code mathematically anticipates 16 and 17-year-old students driving themselves to school. A high school with 30 classrooms must build 180 parking spaces, over 70,000 square feet of asphalt.
Off-street truck loading facilities. A small truck space must have an overhead clearance of 10 feet, be 8 feet wide and 20 feet long. For a delivery van, a large space must have a 14-foot overhead clearance, be 12 feet wide and 50 feet long. For an 18-wheeler semi-truck.
If your gross floor area is between 25,000 and 40,000 square feet, you need one large space. Over 100,000 square feet requires 2 large spaces, plus one for every additional 80,000 square feet.
Article V and Article 8 address what happens when the zoning map is redrawn. Non-conforming uses and non-conforming structures.
If you own a grocery store in a neighborhood that gets rezoned to R1 single-family residential, your store is illegal under the new map.
Section 130-131 states that the lawful operation of a non-conforming use may be continued. You are grandfathered in. But a non-conforming structure cannot be enlarged or extended. You are frozen in time.
Section 130-136. If the non-conforming use is abandoned or discontinued for a period of 6 months, the right is permanently lost.
If the store sits empty for 6 months, the new buyer cannot open a grocery store. They must conform to the current code and build a single-family home.
Section 130-135 dictates the restoration of damaged non-conforming structures. The 60% rule.
If a hurricane damages the store, if we connect this to the bigger picture, this is how the town slowly enforces its master plan. If the store is damaged to the extent of not more than 60% of its replacement cost, you may restore it.
But if the damage exceeds 60% of its replacement cost,
You cannot rebuild. The town will deny the permit. You must clear the rubble and build a single-family home.
Article 8 is a massive ban on manufactured homes. Section 130-201 states that any further placement of manufactured homes within the corporate limits of the town, except in R3 MHP districts, is prohibited.
No new manufactured homes on individual private lots. Section 130-202 states existing manufactured homes are non-conforming. If the home is moved off the lot or destroyed by natural causes, the owner has exactly 6 months from the date of loss to replace it.
If they miss the 6-month window by a single day, the non-conforming use privilege is lost forever. They must build a site-built house or a modular home.
The code states that if the non-conforming home is removed or lost by natural causes and the land is sold, the non-conforming use privilege is invalid. The town is actively zoning out this specific type of housing.
It artificially raises the economic floor required to live there by demanding modular homes with permanent chain wall foundations.
Administration, enforcement, and signs. The Office of Zoning Administration enforces the code. An authorized representative may physically enter into and upon land or a structure to conduct investigations.
They can enter land or a structure other than a dwelling. They cannot enter the interior of the home without a warrant or consent, but they can enter the exterior lot.
Section 130-154 outlines the penalties. Any person violating any provision shall be fined not less than $100, nor more than $500, or imprisoned for not more than 10 days or both for each offense.
Each day that a violation is permitted to exist shall constitute a separate offense. If you ignore an order for 30 days, you face 30 separate offenses, a potential fine of $15,000.
Amending the zoning map is difficult. The applicant must submit a detailed plat and a written description of the market area and economic demand.
The applicant must furnish a list of the names and addresses of the property owners within 300 feet of the proposed district. You must swear before a notary public that the list is complete. The Planning Commission sends a formal notice to every person on the list for a public hearing.
If the application is denied, no land shall be considered again for at least 6 months. If it is approved and you do not build within 1 year, the Commission can revert the zoning.
Article 9 handles sign regulations.
Section 130-234. The mayor may cause a sign to be removed at cost to the owner immediately and without notice if, in his opinion, which shall be final, the sign presents an immediate threat or danger to the safety of the public.
In his opinion, which shall be final, absolute authority over the visual landscape. The town will remove the sign and bill the owner for the labor.
The zoning code is the silent referee of the built environment. It balances private property rights against public nuisance through spatial segregation and mathematical parking formulas.
So, what does this all mean? We have examined the excruciating granular detail of Chapter 130. Every municipality operates on a document exactly like this one. It determines where you buy coffee, the dimensions of your driveway, and whether a factory can manufacture explosives. I want to leave you with one final thought. The code was built for a physical reality: heavy industry, physical retail, and commuting. What happens to this massive, intricate legal structure as our reality becomes digital? The B3 district is designed to contain commercial activity. What happens to that zoning logic when half the town works remotely from their R1 living rooms? What happens when you purchase goods not from a B2 store, but in a virtual reality storefront, delivered by a drone directly to your 10,000 square foot lot? The zoning code is a 20th century physics engine attempting to govern a 21st century digital society. Will these invisible lines hold? Next time you take a walk around your block, look closely. Look at the exact height of the fences. Look at the precise distance from the sidewalk to the front porches. Ask yourself, are the invisible boundaries in your own neighborhood protecting the character of your street, or are they subtly dictating how you live your life? What invisible zoning lines are you crossing without even knowing it?